Today, we are delving into a very important topic, common law and equity. And believe me, after watching this video, as a law student, as a legal method student, as a legal system student, you are going to know everything, the difference between equity and common law. The only thing I need is your attention, and you won't ever ask any question as regards to this law, the difference between equity and common law. If this is the first time you are joining me, my name is Kingsley Ifeanyichukwu Omeyin, better addressed as King's Advocate. I'm currently a 400 level law student, and what I do on this channel is to help law students on the challenges they encounter towards their journey of becoming a lawyer. If what we do here resonates with you, I would encourage you to subscribe, turn the notification on, so that every single Saturday and Wednesday of the week, you'll be able to receive a video. Having said that, let's go into this thing because I'm passionate to teach you about the difference between common law and equity. Because I'm your passionate tutor and I'm not just here to make a video, I will take you into a historical lane. So that when you are talking to your lecturer, you will be speaking from deep ocean of wisdom. What is different between common law and equity without going into historical lane? I will take you into a ride of how common law originated and how equity then came, and to what extent does they apply, and to what extent do we still need it as a student and tomorrow potential lawyer. Let's go into the historical lane to explore everything that has to do with the coming of the common law. The whole journey of common law as we have it today started in the year 1066 when a man named William, who is a French duke from Normandy, invaded England and became the king. William I of England. I don't know whether you people have heard of a man named King William I of England. He was actually a French duke who invaded England. You know, many people didn't know that England was also one time colonized, or should I say, was also one time invaded, just like the Britain invaded us and colonized us. Invaded India, invaded America. Many people don't even know that it was Britain that colonized America, because America later became the world power. Just as China is taking it away gradually with Russia, they are taking the world power from them. So also Britain was one time the world power. Before Britain, there was something like Roman Empire. That is the history we are going to. You will love this topic. It's simple. And these are the beautiful things that the story we are going to say here is not irrelevant, because whatever you'll be writing on this thing is still the story. I could remember my time. We were just meant to examine this. We started writing stories. At the end, you merge it with equity, and you are good to go. It's a typical essay question. It's a crack, as I call it. The method of answering this question is crack. So it's just a way of you answering something smoothly. You know, no need of authority. The whole authority we are going to cite is just this data and history we are going to proceed now. So pay attention here, because it's very, very necessary to your understanding. So as the man who, King William I of England, invaded the entire England, before then, different towns and villages in England had their own rules and customs. So if you live in one part of England, some laws are governing you, or some customs, let's say some customs, we are governing them. Then to some other part of England also, some customs, we are governing them. So there were kind of scattered law everywhere before the coming of this man who invaded, King William I of what? From Duke. But he later became King William I of England. Now, William wanted one system for the whole country, because William was not comfortable with the fact that various laws, just like what happened in our colonial time, like in Nigeria, a typical example, and India, when they came, many laws were governing our fathers, many laws were governing our people. They were not comfortable. They have to fashion out law, sophisticated law we have today. These things still applied in the same England. So they were living from their masters. They were doing the same thing they did to them. So William now wanted a system that is very safe and very good to go. He set up a royal court with judges. That's what he did. These judges traveled around the country, listening to cases and writing down their decisions. So they were going around. Remember, England in the olden days was very large. Before most of this country, got their independence, England was very, very large country. As these judges were going around delivering judgment, they were not just doing it for the sake of delivering judgment. They were writing it down. They were putting it on that paper. Soon, they started applying the same rules everywhere. Those rules then become the common law, because it was common to everyone. I want you to pay attention to what I say. These judges that were, hired by William Charles, the first of England, we are going about applying, ruling in different places. I told you ab initio there was what? Different laws scattered. Then these judges were going around delivering judgments based on the laws that were found in that place. At some point, they begin to write down their judgments. They don't just deliver. They don't just deliver. They begin to write it down. So these decisions they give at some point then become applicable to the whole areas of that place. It become what? Common law. Are you getting the point? So you have just seen how we got the word common law? Because it was common. It was common in application. They were not just delivering. They will deliver today. They will throw it away. They will keep it. They will keep it. They will keep it until it pile up, and they begin to fashion out the judgment, applying it in common manner. It becomes then common law. Give me a like now. What did I do? Give me a like so that this video will get to fellow like you. I will really appreciate it. And tell me the school you are watching this video from, so that I'll better make a video that will suit you through your own course outline. It was through this process we then got what we know as what? Can somebody tell me in the comment section? Writing down judgments, keeping it, and still applying it when other matters arise. What do we have here? I want to know what we have gotten here. We have gotten what? Stay decisive. What is stay decisive? I won't say it. If you can't say it here, you will still learn it before the end of this video. So it was through this process they got what? Stay decisive. They were able to get judgments that continue to stand over each matter. Do you understand? This principle of stay decisive simply suggests that once a judge made a ruling, future judges use that ruling to decide similar cases. That's why I told you people to tell me what I just said. For the sake of this, what we are looking at, judicial precedent. Yes. So this is called stay decisive because it then allowed the decision to do what? To stand. They were not just giving judgment as it pleases them, going around. They were documenting. They were implementing. They were applying it to subsequent cases. That's why we got our first, judicial precedent. The good thing, it made the law very, very consistent and predictable. That is one thing I am now not only, expanding the history, but telling you now the benefit of common law. Because we are not spending the entirety on this video. Otherwise, you will click away. About now, when they have fashioned those laws, they were not just applying it only in a particular case. It will then become territorial and become common. Then, with time, they keep applying those laws. Those laws then become very predictable to an extent that if something happened to you before going to court, you already have a kind of foresight of what judgment you are going to obtain based on what was obtainable between Stanley and Nkechi, between Taiwo and Amedu. You already know that this thing will still apply on my own case. The law become very, very predictable. This is a good example, a good importance of common law. It made the law so much predictable that before going to court, you already have foresight of what you are going to get from the court. But then the bad thing, I'm talking about the implication of common law. I want you to stay at the end of this video because at the end, I'm going to basically tell you how you are going to answer this question, how the question is going to come from your lecturer. I'm a witness, I am a participant, and I have passed through this. I'm ready to help you. King's advocate. I don't joke with freshers. I love law students so much. The bad thing then became that this law became too rigid. Sometimes following the old rules caused unfair results. People were complaining bitterly. Common law not only offered money as damages, but even when money was not enough, you will still get your money. Let us assume. A good example is this. Somebody is building. You have a land that is near to your neighbor. That land belongs to you. Then somebody, just for no reason, because he's building on his own land, went and fenced your own, like extended the boundary of the land and fenced some part of your land. Join. If you go to court, the court will, after listening to your case, once you have established your legal rights, the court will do what? Award you damages. The question now is, I don't want damages, my lord. This gate is touching my own house. This gate has blocked my aid. That is what we call in environmental law as doctrine of easement. Easement means that if somebody is building, whether it's your land or it's not your land, that person owe you a duty of care to ensure there is aid that's going to come to your own house. That person should not block your aid. Are you getting me? That is the doctrine of easement under in environmental law. I don't want to go there much. So this thing was repeatedly being done. You take my land, my lord, I don't want money. Tell this person to demolish this fence. I want my land back. That land is the only land my father had. In fact, it's giving me nostalgia. I don't want this land to be taken away. The court will say, we are giving you money. Don't disturb us again. This was the problem of common law. There was nothing like injunction. Demolish this house. Give this person back his land. Do something else. Just take action apart from money. I don't need your money. Of course, there is not everything money can solve. They say money can't buy happiness. But for now, right, believe me, money can buy happiness. Poverty can't even buy either. So you better pick money. But what are we saying here? There are some legal things that injunction is needed. Electoral matter is one of them. You can't tell me that I lose election, I go to court. You then tell Tinubu to give me 50 billion. For God's sake, 50 billion, does it worth calling me His Excellency? It can't. It can't, my lord. Tell the INEC to turn the thing upside down, or to conduct another election, or to declare all of us non-winners. That is what I want. You are telling Tinubu to give me 1 million. That was common law for me. It was very rigid. It was very, very, rooted in damages. Rather than taking a proactive measure to compensate your injured heart through injunction, it was only giving you money, take. It's just like marrying a rich man. The man don't have time to touch you in the night. The man don't have time to look at your face. The man don't have time to compliment you, to tell you look sexy, you look beautiful. The man don't send your papa everything you need. Money, baby, take money, baby, get out, baby, collect money, baby, buy car, baby, do it, baby, see your money, baby, get clothes, baby, you are looking. The man don't have time. Money. At some point, the lady will be like, I didn't marry money, I married you. Can you touch me? You see that this thing becoming a fulcrum, an issue before the courts. Will you touch me? Oh God. So this was the problem with common law. Now, in the view of this problem, then comes what we have as equity. Good, we are moving. Equity then sees what is going on. It was the harshness, it was the stringent nature of common law that brought what we now have as equity. How did equity arrive? Equity arose based on the fact that people got frustrated and began to petition the king. Your Majesty, common law is too harsh now, please help us. Your Majesty, common law is too harsh now, please help us. Okeke will come. Your Majesty, common law is too harsh now, help me. Stanley will come. Your Majesty, common law is too harsh now. Look at my wife is being taken and they are offering me money. Help me. The king began to be like, what is going on? This law that I have fashioned to help me rule these people that I have taken power from arbitrarily is becoming something else. So if I allow this law to stand, there could be possibility that somebody will overthrow me. Let me do something. Lord, I'm to do something. How can I look and see my people suffer? That was how equity began. The king, noting this petition coming to him, then passed all those petitions to who? The Lord Chancellor. They were his helper. This Chancellor was known as the keeper of the king's conscience. So they were assumed to be the people in charge on the consciousness of the king. Remember, everything about consciousness has to do with reasons and goodwill. So they were the keepers of the king consciousness. The king bestowed them that duty to entertain this matter coming to him, because at some point the king cannot even handle it alone. This court gave new remedies like what? Injunction, that is, stop doing something. Remember I talked about the common law being too rigid, in the sense that somebody is taking your wife, they offer you money. Somebody is trespassing your land. Instead of telling the person to get out of this land, they offer you money. Then the equity then came with injunction. What is an injunction? Injunction is an order of the court restricting or mandating somebody to do something or to refrain from doing something. You have won an election through fraud means, and then somebody have gotten a court order or a win from the court. The essence of that court order is that any person who has been declared winner by the INEC is now not a winner again until further election, or the court can even declare another person the winner, just like Pope Zandima and what the rubbish they did in Imo State. From third, the person become the first. So that is how this thing works. That was how the king, the court of chancery, court of equity began. They started to give injunction. And the beautiful thing about this is that this court, this chancellor were what? Priests. They were priests, priests now, they live by rules, they abide by regulations. They were doing all this thing wholeheartedly with justice, with fairness, just like Martin Luther King Jr. would say that injustice anywhere is a threat to justice everywhere. They understand this principle very well, and they were doing nothing but what? Justice. That's what equity is all about. Now, they not only ended in giving injunction, they started giving what we know as what? Specific performance. Specific performance, just like I told you, simply means that somebody, let us assume that you are building a house. Somebody went to demolish that house in the claim that that house belonged to him. When you got an order of the court, or when you have the matter get to the court and you later win the judgment, for the court of common law, what they will say is give you money. But equity say no, we are mandating this person to build that house for you, not just giving you money. This was how the beautiful thing equity provided. Whatever I'm telling you now is going to be how you're going to write it. And at the end of this video, for them that refuse to click away, for them that refuse not to entertain themselves in TikTok and stay to the end of this video, I'm going to reward you by telling you how you are going to answer this question. Trust me, I will do that for you. Another thing also equity provided was what? Rescission. Rescission simply means cancelling an unfair contract. So where you have contracted with somebody based on duress, for instance, somebody mispresented facts and you then had a contract under common law, that contract is binding. Whether you were duped, whether you were drunken, whether you were insane when you were contracting is immaterial. Once they can see the document you signed it, however you signed it doesn't matter. It becomes binding on you. But equity say no. A court of consciousness. What about if you sign this document unaware? Therefore, you can cancel that contract under equity. But common law, no. Now, at some point there comes a conflict between common law and equity. Of course, you know that since equity is moving towards what? Consciousness. Common law is moving towards what? Strict application of law. So equity there conflicted with common law in such a great way that the justices of the common law were very, very jealous and angry. You know, one of the emotions that can kill and destroy is jealousy. If you are somebody that is very exceptional, you are a destiny child, you are blessed, you are intelligent, if you don't take time, your classmates and your people will eliminate you because jealousy burns. Jealousy is range. Anybody who is jealous, fear that person. He can take your life anytime. So the common law were very jealous. People were no longer coming to them. In fact, people were looking down on them as the wicked guys, as not nice guys. All those things necessitated equity. All those things became the issues, conflict here and there. Then what happened? That is what we are going to tell your lecturer. Sometimes the common law court and court of chancery gave different answers to the same cases, and this created a lot of confusion. The famous case was the case of Earl of Oxford case. This very case is a very, very, locus classicus case. I don't want to go to the fact because of the tiny nature. I want this video not to be long so you don't click away. In our next video, I will possibly address that case. But if you want me to give you the fact of that case, comment on this video. I'm going to send the fact of that case to you so you go through it. Because in that case of Earl of Oxford case, it was very, very serious case that the king himself decided by himself. What was the position of the king in that case? In that case of Earl of Oxford case, the king said that, please, so where there is conflict between equity and common law, let equity prevail. Another case here is case of heredity and heredity. Where there is conflict, common law is saying A, equity is saying B, let B stand because equity will always prevail against the what? Common law. That was when the whole jealousy and everything was what? Mellowed down. Equity becomes what? The most superior authority when it's conflicting with common law. I will send you that case. If you need it, comment in the comment section. I will provide it for you. Now, we also proceed. What about the merger? Like I told you, it's not just enough for you to... Don't worry, I will tell you everything. Let's continue. When we talk about the judicature, the merger, as it stands today, we don't have something like court of equity, court of common law. What we have today is court of law, not court of equity, not court of common law. We have court of law. This court of law is applying both common law as we have it at then and also equity as we have it at today. They are still applying the same thing, but no longer in different courts, no longer by different judges. They have merged it. What necessitated the merger? How did this come about? Let's find out. So, in the Judicature Acts of 1873 down to 1875, I repeat, in the Judicature Act of 1873 down to 1875, that was when the common law and equity was made together. If you want more history on this Judicature Act, tell me also in the comment section. I'll help you on that. By virtue of that Judicature Act, the both courts will merge into one. Today, a single court can now apply both common law and equity like I pointed out. They are still different in spirit, but still the same thing. Common law, certainty, rules, order, equity on the other hand, provide fairness, consciousness, and flexibility. Now, that will lead me to another key point. When we talk about equity, equity simply refers to fairness.